Good morning. We only have a few classes left. Accordingly, while I do believe that it's important that we cover the forms of doing business as well as bankruptcy, there are a lot of material that we're about to have to skip. So if there is any particular chapter remaining in the Miller book that you do believe would be useful for you as a business major to know about in the future, please, in your email regarding the quiz today, include a suggestion as to which ones of those chapters you think would be most useful to you and that you think that we should cover in the limited time we still have available prior to the end of the semester. Thanks. Good morning. Negotiable instruments. Chapter 18 of the Miller book. Negotiable instrument is a signed writing or a record that contains an unconditional promise or order to pay an exact sum on demand or at an unspecified future time to a specific person or order or to bearer. I'm going to repeat that. The definition of negotiable instrument: a signed writing record that contains an unconditional promise or order to pay an exact sum on demand or at a specified future time to a specific person or to order or to bearer. Because negotiable instruments originally were and often still are paper documents, they are sometimes referred to as commercial paper. A negotiable instrument can function as a substitute for cash or as an extension of credit. For a negotiable instrument to operate practically as either a substitute for cash or a credit device, or both, it is essential that the instrument be easily transferable without danger of being uncollectible. Thus, we have special laws regarding negotiable instruments. Learning objectives. Now that we are doing approximately one quiz per lecture in order to hopefully be able to dispense with the need for a final exam, do you recognize that anything that is listed here as a learning objective is apt to come up on a quiz in a subsequent lecture? Accordingly, first and foremost, what requirements must an instrument meet to be negotiable? Second, how does the negotiation of order instruments differ from the negotiation of bearer instruments? And what are the requirements for attaining the status of a holder in due course, HDC? Additional learning objectives include what is the difference between signature liability and warranty liability, and what four defenses can be used against an ordinary holder that are not effective against an holder in HDC or a holder in due course. Types of negotiable instruments. A draft is an unconditional order by which the party creating the draft, who is called the drawer, orders another party, the drawee, typically a bank, to pay money to a third party to whom the instrument is made payable, the payee. This is not necessarily the same as a check. A time draft is payable at a definite future time, whereas a sight draft is payable when it is presented. An acceptance is a drawee's written promise to pay the draft when due or on presentment. A drawee that has so bound itself is an acceptor. Now, as we just noted, typically the drawee is a bank. Trade acceptance, a draft drawn by a seller of goods ordering the buyer to pay a specified sum of money to the seller. The buyer accepts the draft by signing and returning it to the seller, thus, in effect, creating an additional element to the society's money supply. Checks, a draft drawn by a drawer ordering the drawee bank or financial institution to pay a certain amount of funds to the payee on demand. Checks are the most common type of draft. And obviously, unlike a um, time draft, which is only payable at a certain definite future time, checks are by definition sight drafts. Additional types of negotiable instruments include promissory notes, a written promise made by one person, the maker, or one who promises to pay a fixed amount of funds, to pay a fixed sum of money to another person, the payee or subsequent holder, on demand or at a specified future time. Certificates of deposit, which are promises to pay, a note by which a bank or similar financial institution acknowledges receiving money from a party and promises to repay the money, plus interest, to the party or the party's designee on a certain date. This is an example of a typical time draft. You'll notice that while the draft is dated, just like a check would be, in this case, January of 2020, the actual payment date is written out in words, 90 days after above date, which would in fact be a date in April. It still has a pay to the order of line for the payee, in this case the Eastman Supply Company. There is a sum certain listed on this time draft, $1,000. There is a drawer's signature, the president of the company that is issuing the draft, Our Team Real Estate. And we also have listed the drawee, the First National Bank of Whitaker, Minnesota. In all likelihood, this time draft, like other types of draft, would also have both a routing number and an account number that would be recorded along the bottom of the instrument, together with the amount that is due. This is a promissory note, a very short form promissory note. And this is actually the type of promissory note that I was referring to many classes ago when I referred to a person signing a marker at a casino in order to get an extension of credit so that they could continue to lose money there. This is very much the kind of form that a marker would be in. You notice in this case that rather than one maker, we have joint makers. You'll also notice that the payee in this case, rather than being a casino, is a bank, because this is representing a bank loan. It's a short-term instrument because it shows on or before 60 days after the date that these sums are received. Again, it is for a sum certain. It is payable on a future date or on demand, but in this case on a future date. And it has the necessary elements for it to be a negotiable instrument, meaning that it can be freely transferred to someone else in order to have them collect it rather than the initial payee, uh, which is First National Bank of Whitaker, because it's also payable to their order. This is a sample certificate of deposit. It is, in effect, nothing more than a promissory note that is being issued to a depositor by a bank. In other words, you as the payee or the depositor as the payee um, can also be the bearer of the certificate of deposit, so it's freely transferable. Um, the maker in this case happens to be the bank. Again, it represents a sum certain. It calls for the payment of an amount of interest that's easily calculable, and it calls for that payment on a particular future date. So this meets the elements of negotiability as well. And here are those requirements for negotiability. Um, and it's important because while there are many forms of promissory instrument, promissory notes, only certain ones are going to meet the requirements for negotiability. There are also many other kinds of obligations, which are oral obligations and may be legally enforceable, but clearly an oral obligation is not negotiable because, first and foremost, a negotiable instrument has to be in writing. It has to be signed by the maker or the drawer, and that's not possible if you don't have a writing. Um, Third condition is that it has to be an unconditional promise or order to pay. It has to state a fixed amount of money. So it can't be indefinite. It can't be uh, in order to pay the amount of damages that you've incurred because of my breach of a contract, for example. It has to specify a particular amount, whatever that number might be. It has to be payable either on demand or at a definite time in the future. One or the other. Demand notes literally can be paid at any time upon the bearer making a demand. It also has to be payable to order of a particular person or to bearer unless the instrument is a check. Written form. So a negotiable instrument must be written on material that lends itself to permanence and is portable so that it is transferable. There was a famous case back in the 1920s where an English farmer who was very irritated with inland revenue, which is what the English called their Internal Revenue Service, wrote a check for his taxes, actually painted it onto the side of a cow. So the question was, did that writing uh, appear to be on material that lends itself to permanence? Well, it was written on leather. Certainly, the leather of a cow lends itself to permanence. And secondly, was it portable? So it was transferable. Well, the cow was alive and capable of moving around, so the court held that indeed that requirement of negotiability was met by virtue of the fact that the cow was portable. In addition, there are requirements for a signature. For an instrument to be negotiable, it has to be signed by the maker or authorized agent. You must sign the instrument if it is a note or a certificate of deposit. And by the drawer or his authorized agent, who must sign the note or the instrument, I should say, if it's a draft or a check, because a draft or a check is not a note. Nearly any symbol that is adopted or executed by a person with the intent to authenticate A written or electronic document can be a signature. A signature can be made by a device, such as a rubber stamp, or by a thumbprint. In addition, it can consist of any name, including a trade name, or a mark, or word, or symbol. There also has to be an unconditional promise or order to pay. For an instrument to be negotiable, it must contain a promise to pay or an express order. The terms of the promise or order must be included in the writing on the face of the instrument. UCC requires that a promise be an affirmative, express undertaking. A mere acknowledgement of a debt is not sufficient without evidence of an affirmative undertaking on the part of the debtor to repay the debt. Associated with three-party instruments such as checks, drafts, and trade acceptances, an order must command a third party to pay the instrument as drawn. Thus, a check which says pay to the order of is just that. It is a direction, an order. It is more than just an acknowledgement of a debt. It is a direction to the bank in which you are holding funds in an account to make payment from that account to the person who presents the check. Associated with third-party instruments such as checks, drafts, and trade acceptances, an order must command a third party to pay the instrument as drawn. Like I just said, a promise or order is conditional and therefore not negotiable if it states an express condition to payment. So, if a check is written out but says that upon the delivery of a waiver, this check shall cause the bank to pay $5,000 too, then it's not a negotiable instrument. That also has to state that the promise or order is subject to or is governed by another writing. In that case, it's not a negotiable instrument. Or that the rights or obligations with respect to the promise or order are stated in another writing. A mere mention of another writing by itself and in and of itself and nothing more than that is insufficient to make the promise or the order conditional. But if, in fact, it makes itself subject to the terms of the other writing, then the check is conditional in such a way that it is no longer a negotiable instrument. The additional requirements for negotiability: a fixed amount of money. Negotiable instruments must state with certainty a fixed amount of money to be paid at any time the instrument is payable. This requirement ensures that the value of the instrument can be determined with clarity and certainty. The term fixed amount means an amount that is ascertainable from the face of the instrument. The fixed amount must be payable in money. The UCC defines money as a medium of exchange authorized or adopted by a domestic or foreign government as part of its currency. Thus, Federal Reserve notes, which certain odd people have claimed is not in fact money, are, for purposes of the UCC, money because they are part of the currency of the United States of America. And arguments that either only silver certificates or some other medium of exchange that is redeemable in the form of specie or valuable currency, money, metallic currency, is simply nonsense. Payable on demand means that an instrument is payable on demand at sight or upon presentment if it is subject to payment immediately upon being presented to a payor or a drawee. Presentment is the act of presenting an instrument to the party liable on the instrument in order to collect payment. Presentment also occurs when a person presents an instrument to a drawee for a required acceptance. So, if you have a draft written on a particular bank, the only way that you can guarantee that it is to be payable is by presentment to the bank in which the funds are being held. Payable on demand or at a definite time, which is the alternative to um, uh, paying on demand, is paying at a definite time. Definite time means an instrument is payable uh, if it states it's payable on a specified date within a definite period of time, or on a date or a time that's readily ascertainable as the time the promise or order is made. Thus, a draft that contains the date and makes the statement payable 90 days after the above date is in fact a date or a time readily ascertainable at the time the promise or order is made. An acceleration clause allows a payee to demand payment if a certain event occurs um, with interest. Um, and, for example, such as the failure to pay an installment when it's due. So you have a stream of payments, you miss one, there is almost undoubtedly going to be an acceleration clause contained within your promissory note, which causes you to then owe the entire amount of the note. An extension clause is a clause in a time instrument that permits the date of maturity to be extended. These are included in a lot of instruments and are actually being invoked to a great extent right now due to the COVID-19 crisis. There are all kinds of promissory notes that are receiving automatic 30, 60-day extensions as a matter of the grace um, of the payors. Continuing with requirements for negotiability. Payable to order or to bearer. Because one of the functions of a negotiable instrument is to serve as a substitute for cash, freedom to transfer is essential. This goes back to economics, if you recall the M1 money supply and the M2 money supply. To ensure a proper transfer, the instrument must be payable to order or to bearer at the time it is issued or first comes into the possession of the holder. Otherwise, it is not negotiable. So, an order instrument is a negotiable instrument that is payable to the order of an identified payee. For example, pay to the order of John Doe, or to an identified person or order. In other words, say pay to John Doe or order. A bearer instrument, on the other hand, is an instrument that is not payable to a specific person, including any instrument that's payable to a bearer or to cash. So, a bearer is a person in possession of an instrument payable to the bearer or endorsed in blank. So even if I have an instrument that is payable to the order of John Doe, if John Doe signs the back of the instrument and hands it to another person who is then the bearer, um, they are able to negotiate it as a bearer because it's been endorsed in blank. Any instrument that's payable to the following is a bearer instrument. Payable to the order of bearer, payable to John Doe or to bearer, payable to bearer, payable to X, or pay to the order of cash. Like any contract, as long as all the material terms are stated, negotiable instruments are going to be negotiable. And certain things that are factors that might otherwise affect elements of the instrument are not going to affect negotiability if they're not considered to be material to that aspect. Those include the fact that the instrument is undated, That doesn't affect its negotiability unless the date of the instrument is necessary to understand the payment term. So the undated draft, time draft, that states 90 days after the above date as being the date that is payable, if there is no above date, would in fact no longer be negotiable, because you have to have a reference to that date in order to establish when in fact the instrument is payable. Whether or not the instrument is post-dated or antedated is not going to affect its negotiability. Handwritten terms on an instrument are going to outweigh typewritten terms, if you still find those. And typewritten terms are going to outweigh printed terms. In the past, there were a lot of form negotiable instruments that people would pick up at legal stationery stores and then go type in other terms, and then conceivably thereafter, once they're negotiating the actual terms of the note, handwrite terms that would amend both of those things. Words outweigh figures unless the words are ambiguous in and of themselves. So if you have a check and the check has in numbers $100, but in the actual payment line you have written out 1,000 and no 100th dollars, the words 1,000 are going to outweigh the figures of 100, and your check will be negotiable for $1,000 as a draft rather than as for just 100. Notations that an instrument is non-negotiable or not governed by Article 3, since negotiable instruments are governed by Article 3 of the UCC, do not affect the negotiability of a check, but might make other instruments non-negotiable. So writing non-negotiable in the informational line of a check is not going to make the check non-negotiable upon it being endorsed in blank. It might, however, make a promissory note or a certificate of deposit non-negotiable. Okay, once again, everybody, I'm going to tell you, you need to read the chapter that's in the book. Cengage has made it freely available to everybody for the duration of this term, so go do that. However, I am going to sum up what is in the Charles R. Tibbs Family Trust versus PB Commercial LLC case. Essentially, there was a loan, and the words were for $1,007,000, while the number that was typed in was $1,700,000. Because the words were only $1,007,000, this Texas court essentially let these people off of $693,000 worth of obligation. Because obviously, if the bank had been on its toes, it would have made them match. There's no ambiguity here. In the case of words controlling over numbers, the court is saying this is not a question of an ambiguity. This is a simple rule of construction that words control over numbers. Here we have, suppose that the note had described the amount of the loan as $1,700,000 and no 100ths, and then shown the numbers $1,007,000. They asked what would be the result. Well, this Texas court, if it's being consistent, would have held that they were liable for the entire $1,700,000 because that's the amount that was written in words. And the amount that is actually written in numerals would be $673,000 less. I'm going to point out one more time One of the problems with a survey course, such as the one we have here, is that while negotiable instruments is a relatively compact area of the law, when I took it in law school, it was nonetheless still a 2-hour course. And by 2 hours, I mean for a semester. In our case, we're going to try to cover the whole area of negotiable instruments in an hour. Not a semester hour, but an hour. Transfer of instruments. Assignment. Under general contract principles, a negotiable instrument can be assigned, thus transferred to an assignee, who then holds the instrument with all the rights of the assignor. Negotiation. Transfer of an instrument in such a form that the transferee, the person to whom the instrument is transferred, becomes a holder who has at least the same rights in the instrument as the transferor and may have more rights than the transferor. Negotiating order instruments. An order instrument contains the name of a payee capable of endorsing it, as in pay to the order of Lloyd Sorensen. If the instrument is an order instrument, it is negotiated by delivery with any necessary endorsements. Negotiating a bearer instrument. If an instrument is payable to bearer, it's negotiated by delivery. There's no reason to endorse it, no reason to sign anything. You just transfer it into another person's possession in order to accomplish the negotiation of a bearer instrument. An endorsement is a signature, with or without additional words. For example, it could say for deposit only, or payable to Jane White, or payable from account number whatever, etc. So an endorsement may or may not have these additional words, which is made by the endorser in order to transfer his or her rights to the endorsee. There are 4 major categories of endorsement, one of which is required whenever an order instrument is going to be negotiated. I'll tell you what they are. They're blank endorsements, special endorsements, qualified endorsements, and restrictive endorsements. So we'll go over the first 2 of those now. A blank endorsement is an endorsement that specifies no particular endorsee and can consist of a mere signature. A special endorsement is an endorsement that indicates the specific endorsee to whom the endorser intends to make the instrument payable. Thus, you'd have an instrument that says payable to John Doe. John Doe could then sign an endorsement saying payable to the order of X, and that endorsement is then makes the instrument only payable to X. A qualified endorsement is one which disclaims any contract liability on the instrument. For example, it will say without recourse. Qualified endorsements are often used by endorsers acting in a representative capacity, the effect of which is to relieve the endorser from personal liability on the endorsement. A special qualified endorsement includes the name of the endorsee as well as the words without recourse. The special endorsement makes the instrument an order instrument, requiring an endorsement plus delivery for negotiation. However, a blank qualified endorsement without recourse signed by John Doe makes the instrument a bearer instrument, and only delivery is required for negotiation. Restrictive endorsement is any endorsement on a negotiable instrument that requires the endorsee to comply with certain instructions regarding the funds involved. So a conditional endorsement is an endorsement that makes payment of the instrument dependent on the occurrence of some event specified in the endorsement. An endorsement for deposit or collection is an endorsement that makes the endorsee a collecting agent for the endorser, prohibiting further negotiation except by a bank or financial institution engaged in collection activities. A trust endorsement or an agency endorsement is an endorsement to a person who is to hold or use the funds for the benefit of the endorser or a third party. A couple of miscellaneous endorsement issues. As a general rule, an endorsement should be identical to the name appearing on the instrument. However, when the endorser's name is misspelled on the instrument, she may endorse it as is, which is incorrectly, or as it should correctly appear, or both. And I would say the better practice is that you sign it both ways. On the other hand, an instrument payable to two or more persons jointly, for example, pay to Bob and Jill, requires the endorsement of both of the payees. If it's unclear whether an instrument is payable to two or more persons jointly, or in the alternative, courts will construe it as being payable in the alternative. Holder in due course, or what is commonly called an HDC. A holder who acquires a negotiable instrument for value in good faith and without notice that the instrument is defective is called a holder in due course. What are the requirements? An ordinary holder obtains only those rights that the transferor had in the instrument and normally is subject to any defenses that can be asserted against the transferor. In contrast, a holder in due course takes an instrument free of most of the defenses and claims that can be asserted against the transferor. A holder of a negotiable instrument who is an HDC, if she or he takes the instrument for value in good faith and without notice that it is defective. A holder can take an instrument for value by performing the promise for which the instrument was issued or transferred, or by acquiring a security interest or other lien in the instrument, excluding liens obtained by judicial process, or by taking an instrument in payment of or security for an antecedent debt, or by giving a negotiable instrument as payment, or giving an irrevocable commitment as payment. Future value. A person who promises to perform or give value in the future cannot be an HDC because a holder takes an instrument for value only to the extent she has performed as promised. In addition to taking for value, a holder in due course must also take in good faith. An HDC must acquire an instrument honestly and in a manner consistent with reasonable commercial standards for fair dealing. The good faith requirement applies only to the holder, not the transferor. So the transferor can, in fact, be a used car dealer who is making a transfer in absolute faith. As I mentioned, the holder has to take for value, has to take in good faith, also has to take without notice that the instrument being acquired is defective. So, the following ways are ways in which an instrument could be defective, and if the holder in due course, or the person who would like to be a holder in due course, is aware of any of these, then they cannot, in fact, be an HDC. They include the fact that the note is or instrument is overdue, that the instrument has been dishonored, that it's part of a series of which at least one instrument has an uncured or uncorrected default, that the instrument contains an unauthorized signature or has been altered, that there is a defense against the instrument or a claim to the instrument, or that the instrument is so irregular or incomplete as to call its authenticity into question. The holder is considered to have notice of a defect whenever he or she has actual knowledge of the defect, has received notice of the defect, that is, for example, a letter from a bank identifying the serial number of stolen checks, or has reason to know that a defect exists given all of the facts and circumstances known to him or her at the time. Overdue instruments. Demand instruments overdue if an unreasonable length of time has passed after the issue. And the time instrument is overdue after the due date check. Dishonored instruments. If the holder knows or has reason to know that an instrument has been dishonored, the holder is on notice and cannot claim HTC status. Conversely, if a person purchasing an instrument does not know and has no reason to know that it has been dishonored, the person is not put on notice and therefore can become an HTC. The word dishonor in this context means to refuse to pay or to accept a negotiable instrument that has been presented in a timely and proper manner. Notice of claims or defenses. A holder cannot become an HTC if he or she has notice of any claim to the instrument or any defense against it. A purchaser has notice if the claims or defenses are apparent on the instrument's face, or if the purchaser has reason to know of them from facts surrounding the transaction. Any irregularity on the face of an instrument, such as an obvious forgery or alteration that calls into question its validity or ownership, will bar HTC status. A purchaser cannot become an HTC of an instrument which is so incomplete on its face that an element of negotiability is lacking, although minor omissions are permissible. The shelter principle. Basically, this is how to establish being a holder through an HTC. A person who does not qualify as an HTC can, nonetheless, acquire the rights and privileges of an HTC if he derives his title to the instrument through an HTC. However, a person who previously held the instrument cannot improve his position by later reacquiring it from an HTC if the former holder was a party to fraud or illegal activity affecting the instrument or had notice of a claim or defense against the instrument. Thus, you can't cleanse your knowledge by virtue of using an intermediary HTC. Signature and warranty liability. Under signature liability, primary liability belongs to the person who, on a promissory note, has unconditionally required to pay the instrument, unless, of course, he or she has a valid defense of the payment. Only makers and acceptors, drawees that promise to pay when the instrument is presented, are subject to primary liability. Secondary liability. A contingent requirement to pay a negotiable instrument upon dishonor or the failure to pay or accept by the party primarily liable on the instrument. So only drawers and endorsers are subject to secondary liability, and only if the instrument is properly and timely presented, the instrument is dishonored, and the secondarily liable party is given timely notice of the dishonor. Proper and timely presentment. The party to whom presentment must be made depends on the type of the instrument involved. A note or CD must be presented to the maker, whereas a draft or check must be presented to the drawee. Presentment can be made by any commercially reasonable means, including oral, written, or electronic communication. Failure to present an instrument on time is the most common reason for improper presentment. If the instrument is payable on demand, the holder should present it for payment or acceptance within a reasonable time. Dishonor and notice. As mentioned, an instrument is dishonored when the required acceptance or payment is refused. It is also dishonored when acceptance or payment cannot be obtained within the prescribed time or when the required presentment is excused, as it would be, for instance, if the maker had died, and the instrument is not properly accepted or paid. A delay in payment or a refusal to pay an instrument will not dishonor the instrument. When presentment is made after an established cutoff hour, not earlier than 2 p.m., a bank can postpone payment until the following business day without dishonoring the instrument. When the holder refuses to exhibit the instrument, to give reasonable identification, or to sign a receipt for the payment on the instrument, then a bank's refusal to pay does not dishonor the instrument. When an instrument is returned because it lacks a proper endorsement, the instrument is not dishonored. Once an instrument has been dishonored, proper notice must be given to secondary parties, drawers, and endorsers, for them to be held liable. Unauthorized signatures. When a person forges another person's name on a negotiable instrument, or when an agent who lacks the authority signs an instrument on behalf of a principal, it is considered an unauthorized signature. As a general rule, unauthorized signatures are wholly inoperative and will not bind the person whose name is forged. However, an unauthorized signature will bind the person whose name is forged if that person ratifies or affirms the obligation, or that person's own negligence substantially contributed to the forgery. The first party to accept an instrument bearing an unauthorized endorsement will bear the burden of loss, unless the unauthorized endorsement is that of the payee, in which case the loss falls on the drawer or maker. The imposter rule. An imposter is one who, by use of the mails, telephone, or personal appearance, induces a maker or drawer to issue an instrument in the name of the imposter. Endorsements by imposters are not treated as being unauthorized. A fictitious payee. A payee whom the maker or drawer does not intend to have an interest in the instrument. For example, where a dishonest employee issues an instrument on his employer's behalf or deceives the employer into signing an instrument payable to a party with no right to receive payment. Transfer warranties. Warranty liability arises even when a transferor does not sign the instrument. Unlike secondary signature liability, warranty liability is not subject to the conditions of proper presentment, dishonor, or notice of dishonor. Transfer warranties. That any person who transfers an instrument for consideration impliedly warrants to subsequent transferees and holders who take the instrument in good faith that, first, the transferor is entitled to enforce the instrument. Second, that all signatures are authentic and authorized. Third, that the instrument has not been altered. Fourth, the instrument is not subject to a defense or claim of any party that can be asserted against the transferor. And finally, the transferor has no knowledge of any insolvency proceedings against the maker, the acceptor, or the drawer of the instrument. Presentment warranties. Any person who presents an instrument for payment or acceptance impliedly warrants that he or she is entitled to enforce the instrument or to authorize or obtain payment or acceptance on behalf of a person who is entitled to enforce the instrument. There are also impliedly warranting that the instrument has not been altered and that they have no knowledge that the issuer's signature is unauthorized. Universal defenses are those that can be used to avoid payment to all holders of a negotiable instrument, including a holder in due course or a holder with the rights of an HDC. These are also called real defenses. First, forgery. Forgery of a maker's or drawer's signature cannot bind the person whose name is used unless that person ratifies the signature or is precluded from denying it. For example, because the forgery was made possible by the maker's negligence. Second, fraud in the execution. A person whose signature is obtained through fraud or deception is generally not liable unless reasonable inquiry, in light of, among other things, the signer's age, experience, and intelligence, would have revealed to the signer the nature and terms of the instrument. Third, material alteration. An alteration that changes the terms of the instrument between two parties in any way. For example, by adding words or numbers. Material alteration is a complete defense against claims of an ordinary holder. Material alteration is a partial defense against an HDC, only to the extent of the alteration. Discharge in bankruptcy. Discharge is an absolute defense against the claims of any holder, including a holder in due course. Minority. Minority is a defense to liability on an instrument to the same extent it is a defense to contract liability. Illegality. Any illegal act that would render a contract void under state law is an absolute defense against the claims of any holder, including HDCs. Mental incapacity. Any instrument made or issued by a person previously adjudged to be mentally incompetent is void ab initio and therefore unenforceable by any holder, including an HDC. Extreme duress. Any instrument signed and issued under immediate threat of force or violence is void and unenforceable by any holder, including an HDC. Personal defenses. These are defenses that can be used to avoid payment to an ordinary holder of a negotiable instrument, but not a holder in due course, or a holder with the rights of an HDC. These are also called limited defenses. A breach of contract or warranty. When there is a breach of an underlying contract for payment of what the negotiable instrument was issued for, or of a warranty arising from that contract, the maker of a note can refuse to pay it, or the drawer of a check can order his bank to stop payment. Lack or failure of consideration. The absence of consideration may constitute a defense in some cases. Fraud in the inducement. A person who issues a negotiable instrument based on false statements by another party can avoid payment unless the holder presenting the instrument for payment is an HDC. Illegality, mental incapacity or ordinary duress. If the law declares that an instrument is voidable because of illegality, mental incapacity, or ordinary duress, the defense is personal. Personal defenses include federal limitations on the rights of holders in due course. FTC Rule 433 limits a holder in due course's rights in an instrument arising out of a consumer credit transaction. Rule 433 applies to any seller of goods or services who takes or receives a consumer credit contract or accepts as full or partial payment for a sale or lease the proceeds of any purchase money loan made in connection with a consumer credit contract. The purpose of Rule 433 is to protect consumers from being forced to pay a third party for a defective good and then incur the cost of pursuing the seller separately. As a consequence of Rule 433, a consumer who purchases a defective product may assert the defect as a defense to any claim for payment by the seller or any subsequent holder, including an HDC. Discharge from liability. If a party primarily liable pays the instrument in full, all parties on the instrument are discharged. If a secondarily liable party pays the instrument, only that party and subsequent parties are discharged. The primary party, maker or drawer, and any endorsers prior to the paying party remain liable. Intentional cancellation, i.e. writing paid across the face of an instrument and then destroying the instrument, discharges the liability of all parties. Material alteration may discharge the liability of any party affected by the alteration. If a party's right of recourse, that is, right to seek reimbursement, has been impaired, that party may be discharged from further liability. Chapter 17 Matching Quiz, due March 30th, 2020 before midnight by email sent to me. Question 1. Goods that conform to contract specifications. Question 2. Accept all, reject all, or accept part and reject part. Question 3. The seller's residence. Question 4. First step of shipment contract. Question 5. Give notice of delivery. Question 6. Right to cure. Question 7. Commercial impracticability. Question 8. Cost of inspection. Question 9. Seller can withhold delivery. Question 10. Destruction of goods. The answer bank. A. Borne by buyer. B. First step of destination contract. C. Conforming goods. D. Deliver goods to carrier. E. Perfect tender rule. F. Possible place of delivery. G. Exception to perfect tender rule. H. Perfect tender no longer applies. I. Breach by buyer before shipment. And J. Excuses performance.